ಕೊಡ್ಲಾ? ಕೊಟ್ಟೆ. ಹಲೋ ಚೆಕ್. Hello, mic checking, mic checking.
We are 30 seconds shy of 6 o'clock, so we'll start the program exactly at 6. Good evening, everyone. A very warm welcome to all of you for one more endowment lecture program. So today we have Professor N.A. Nikam, Srimati Rajalakshmi Anand and Sri H.N. Anand and Srimati Swayamprabha Balraj Memorial Endowment. So I request today's dignitaries, the Chairperson Padma Vibhushan Justice M.N. Venkatachaliah ji and Dr. T.R. Subrahmanya and our President Dr. Satyavati to come to the stage and occupy the chair. Just 3 days back, we celebrated our Independence Day, and as a true democracy, today's lecture topic is on Uniform Civil Code, which has been at the center of attention of all of us and has led to several deliberations of late. So it was very apt for us to keep this particular topic for today's endowment program. And we have our speaker for today's lecture, Dr. T.R. Subrahmanya. And it is truly an honor and privilege for all of us that Justice M.N. Venkatachaliah ji has accepted to chair today's endowment lecture. And Justice M.N.V. literally doesn't need any introduction at all. He was appointed the judge of Karnataka High Court in 1975 and elevated as judge of the Supreme Court of India in 1987. Later, he became the 25th Chief Justice of India on 12th February 1993 and subsequently retired on 24th of October 1994. He served as the chairman of the National Human Rights Commission and also headed National Commission to review the working of the Constitution. He continues to head advisory board of several prestigious institutes across the globe, and he has received numerous honorary degrees and hundreds of recognitions from reputed organizations all over the globe. He has been bestowed with India's second highest civilian honor from the President of India in 2004, the Padma Vibhushan. Justice M.N.V. has guided this institution as its president for over a decade and continues to motivate all of us as the chairperson of our advisory board. He is the most youngest of all of us in terms of his energy and motivation. So thank you once again, sir. So welcome, a hearty welcome, and thank you once again for chairing today's lecture. And today's guest speaker, Dr. T.R. Subrahmanya, excelled in academics as a student. After his MA in History and LLB, he completed LLM from Mysore University with first rank. He went on to secure an MPhil, a PhD in International Law from the School of International Studies, JNU, New Delhi. Professionally, he has served as Registrar Evaluation, Registrar Administration of Bangalore University, Dean and Chairman of the Faculty of Law, Bangalore University, Vice Chancellor, Bangalore University, Vice Chancellor of Karnataka State Law University, Hubballi, has been Professor of International Law at West Bengal National University of Juridical Sciences, served as the Honorary Member of the Karnataka State Law Commission. At the international level, Professor Subrahmanya has served as Legal Counsel to the Kingdom of Bahrain for over 7 years. Currently, he is the Dean of CMR University College School of Legal Studies, Bangalore. Apart from several papers published in a variety of national and internationally renowned journals, Dr. Subrahmanya published a book entitled The Rights and Status of the Individual in the International Law, and also edited Human Rights in International Law. His most recent book was released in 2021 by Routledge on hazardous substance in India and the world, legislations, framework and management. In 2009, he was awarded Dr. Rajkumar State Award for services rendered in the field of education, and he was honored with the Vijayawani National Educational Leadership Award for outstanding contribution in the field of education. Besides several awards and other recognitions what has been bestowed by several organizations. I will not go into the entire citation here. He is a distinguished visiting faculty for several universities and serves on the panel of advisors, board of studies, academic council and panel of examiners and several prestigious law schools. So I once again heartily welcome Professor T.R. Subrahmanya for accepting to provide the lecture for today's endowment program. And as is the norm, before we start the lecture, so I would like to make a brief introduction of the three endowments which has been kept for today's lecture. We have Professor N.A. Nikam endowment, Srimati Rajalakshmi Anand and Sri H.N. Anand endowment, and then Srimati Swayamprabha Balraj Memorial endowment. So three endowments have been supporting this particular lecture, and I would like to go through each one of them and their details. And a couple of them are very close to this institute itself by their association and also their children. Professor N.A. Nikam Memorial Program, it's one of the longest running endowment which was instituted way back in 1979 by his daughter, Dr. Shakuntala Mane, who also was the executive committee member. She is there with us. So I welcome you and the family to this particular lecture program, madam. Welcome. Professor N.A. Nikam had his education in Mysore and Cambridge, England. He was awarded the Baba Memorial Gold Medal by the Mysore University and a recipient of the Damodar Das Foreign Scholarship by the state government for his studies in England. After his teaching career in Bangalore at the Fort High School and later at Maharani's College for Women, the Rajaram College, Kolhapur and Maharajas College, Mysore, Professor Nikam became the Vice Chancellor of Mysore University in 1960. As Vice Chancellor, Professor Nikam planned and developed new campus for the Mysore University, that is Manasa Gangotri, where the postdoctorate departments came to be located. It was due to his vision that the Mysore University got its first postgraduate departments in the science faculty. Professor Nikam had close association with the Maharaja of Mysore, the late Sri Jayachamrajendra Vadiyar, and it continued throughout his life. In USA, Professor Nikam, a recipient of the Fulbright Scholarship and Ford Foundation grant, was an associate fellow at the Yale University. He was the Berkeley Archson Visiting Professor of International Studies at the McAllister College, St. Paul, Distinguished Professor at the California State College and the Southern Illinois University. Professor Nikam was an active member of many learned societies, cultural and academic institutions, both in India and abroad. In his capacity as the elected Secretary, Indian Philosophical Congress for 12 years, he organized two roundtable conferences under the East-West Major Project of UNESCO, one at the University of Ceylon and the other at Australian National University, Canberra. Professor Nikam's training in Western philosophy, ancient and modern, helped him to have a deeper understanding of Vedic source of Indian thought and culture. He imbibed not only the spirit of the Upanishads, but also the enigmatic style of expressions. These are reflected in the several books which he authored, and notable among them are the 10 principal Upanishads, Sense, Understanding and Reason, Philosophy, History and the Image of Man, the Edicts of Ashoka, published by the Chicago University Press, and it was edited by Professor Nikam along with Professor Richard McKeown. This book is translated into French, Italian, Polish, Japanese and Hebrew. Professor Nikam had a deep bond of friendship with Madam Sophia Wadia and Sri B.P. Wadia, the founders of Indian Institute of World Culture. It is most appropriate that the annual Nikam Memorial Lecture, sponsored by his family, is held at the same venue where he delivered many distinguished lecture programs. Dr. Shakuntala Mane, again, who is present today for this lecture, has served as the executive committee member of this institute. So I thank her and also welcome her again. And also her younger sister, Dr. Shailaja Nikam. Sorry. So thank you once again. Srimati Rajalakshmi and Sri H.N. Anand Memorial Program. Sri Anand had many facets to his personality. A civil engineer by profession, he was actively involved in a number of large projects with Bokaro Steel, Engineers India, Tata Projects and other organizations. He was also a keen patron of the fine arts, classical music and dance programs which were very close to his heart. After retirement, he got involved in numerous religious and spiritual activities. His lifestyle was very disciplined and he believed in punctuality. He was not very talkative by nature, but believed in doing a lot of philanthropic work quietly. This endowment has been instituted by his daughter, Srimati Mrudala Vyas, since 2014. So I once again welcome the family members of Srimati Rajalakshmi and Sri H.N. Anand to this particular memorial and thank them. The third endowment, that is Srimati Swayamprabha Balraj Memorial. She was born in 1952 to Sri Pobati Vishwanath Shetty and Srimati Navaratnama. She completed her BSc and went on to secure a rank in MA Kannada. She wrote many poems, short stories and articles in Kannada. Some of her works were published during the Golden Jubilee of Kannada Sahitya Parishad. By nature a friendly and humorous person with a keen ear for music, she can be identified by her diverse talents. Her husband, P.C. Balraj, with an interest in literature, has instituted this endowment program in her name since 2016. And again, Sri Balraj has been closely associated with this institute and he has served as the executive committee member and literally he is our neighbor here. So next door. So I welcome Balraj, who is present for today's lecture, and also his family. So I thank all the three endowment families for instituting this particular lecture. And now I request Professor T.R. Subrahmanya to deliver his lecture.
A very good evening to all of you present here. Honorable former Chief Justice Padma Vibhushan M.N. Venkatachaliah ji and Madam who is Satyavati ji and Mr. Venkatesh, who is the Secretary, and all the people who are responsible, three of them, in sponsoring this lecture, and all the dignified ladies and gentlemen. Uniform Civil Code is gaining momentum today. It is gaining momentum at the offices of the political parties as well as even in the minds of citizens of this country. Now, before I come to the Constitution and its provisions, which our Honorable Sir will be in a position to highlight you much better than me, I just intend to speak to you something known as codes, C-O-D-E-S. What is this code? Are there any instances or illustrations wherein when a state has adopted a code, did it include like the law of marriage, the law of succession, the law of transfer of property, or the law of wills, or the law of gifts? This is the fundamental question which we should know. Otherwise, it is very difficult for anybody to speak on uniform civil code. Now, the Roman Empire came to be established in 529 BC, before Christ. And Justinian happened to be a famous emperor whose, remember, life and style and imagination is being studied by students of history as well as students of law. Justinian, during the course of his administration, thought of establishing a Roman code, which later was called as the civil law of Rome. So the civil law of Rome, which is called as Jus Civile, how it came to be established? In order to bring in Jus Civile, the civil law of Rome, Justinian had appointed several law commissioners, and these law commissioners were requested to draft and put in the existing law by way of courts. So when they were requested to put in the law by way of courts, the task was not that easy, because he wanted it to be a permanent code, regularly to be applied, regularly to be practiced. So when I speak of the code, remember, it had not only the substantive law, but included the procedural law as well. For purpose of including this, the commissioners, the law commissioners, remember, had to put hard work. Having put hard work, they were able to establish the Roman codes. And these Roman codes which were established comprised of what? It comprised of what we call as the law of property. It comprised of the law of succession. It comprised the law of endowments. It comprised other branches of law relating to individual liberty, marriage, and succession as well. That is why the Roman society was able to function very effectively. And the state of Rome had conquered several cities. And when they conquered several cities, it became part and parcel of the state of Rome. And the law that was enacted by them was made applicable in these territories as well. Now, when we come to what we call the 3rd century BC, they made another code as well, along with the Jus Civili, that is the civil law of Rome. They made another code. And this is what we call as Jus Gentium. Now, Jus Gentium simply means it is a law that was enacted only to the foreigners. In the event of a foreigner visiting the territory of Rome, in the event he was finding in the jurisdiction of the state of the Roman Empire, a separate law was made applicable, and this Jus Gentium at a later stage was called as international law, law of nations. Now, this is how it is being done and followed and accepted. And the Roman Empire, from, as I just pointed out, from 573, Justinian's period came in 529. From 573 to 31 BC, they ruled the empire. And remember, they ruled the empire very effectively because of Jus Civili. This is a fact of life, which everyone points out if you read the history of the Roman Empire. Now, what has happened was the glory of the Roman code spread far and wide. And it entered the portals of the state of Germany. And the state of Germany wanted to practice this, and a few of the codes were applied by the state of the Roman Empire. Now, thereafter, what has happened was the state of Austria, when we come to the modern times, adopted the Roman codes. See, the very purpose of telling this is the impact of Jus Civili, or the civil law of Rome, brought in by Emperor Justinian, ably assisted by the commentators on law like Appian, Pelpian, Gaius, and a host of others were responsible in keeping its durability. Now, it spread to the state of Austria, then it went to the state of Prussia. Thereafterwards, it was accepted and practiced even in the Bavarian Republic. That is the greatness of the Roman codes, because it contained all laws, including marriage, succession, and transfer of property, etc., etc. Then we come to the history of the state of France. When we come to the history of the state of France, there was a great emperor. And this emperor has fought more than 40 wars, and he was a great success as well. And he is none but Napoleon. Napoleon, the moment he came to power, he became the general as early as 1893 and became the emperor in 1804. 1793, he is the general, and 1804, he became the general of the state of France. So immediately he asked the advisors, especially the legal officers who are eminent men, to draft a code for the state of France. It is popularly known later stage as Napoleonic Code or Code Napoleon. Now when we speak about Code Napoleon, remember, the first part is there were as many as 300 laws which were prevalent in the state of France when he became the emperor. And all these 300 laws were to be converted into codes. Now when I speak about converted into codes, it should have substantial law as well as procedural law. How it should be applied, and in what manner it should be applied, to which court it should go. That also was pointed out, and Code Napoleon, remember, became. A great historian by name Granton Temperley, while speaking about Code Napoleon, he just pointed out, if the wars of Napoleon were ephemeral in nature, it lasted only for a few years. His civilian administration, because of Napoleon Code, was built on granite. It was so perfect, so sound. And when Napoleon, remember, was taken to St. Helena after the Battle of Waterloo, he survived up to 1821, although he was defeated in 1815. Many states wanted to accept it. Remember, it ditto, just like copycats. Now there were states which were under the occupation of Napoleon. And most of them happened to be European states. One such state happened to be the state of Holland. The second state happened to be the state of Luxembourg. And these states, remember, accepted Napoleonic Code for several years, almost 80 years it went on practicing. Later it spread to the other part of the state of Europe. And many of the European countries had accepted the Napoleonic codes. The impact of Napoleonic Code was such, it even went to Latin America. Both the state of Haiti and the Dominican Republic adopted Napoleonic Code even without a single change. Now this code, remember, naturally contained everything. It is not only law of marriage. It contained, spoke about the law of divorce, the law of property, the law of succession, all of them. They were part of the code. And that is where it was able to influence even Latin American countries. And at a later stage, even Chile, the state of Chile, and Laos followed the Napoleonic Code. This, in brief, remember, is something relating to the Napoleonic codes and their influence, and prior to that, the Roman codes. Now, what about the prevalence of what we call as the directive principle of state policy, as well as Article 44 of the Constitution of India? Now, when I speak about Article 44 of the Constitution of India, it simply says, the state shall endeavor to provide what we call as uniform civil code to its citizens throughout the territory of India. So it is in Part 4 of the Constitution. Since it is Part 4 of the Constitution, the courts cannot give a directive to enforce it. But most importantly, Part 4, remember, is the actual guide for the governance of this country. The governance of this country has to take place through this code only. Now, when thereafter we'll just go to the Constituent Assembly itself and the debates. Now, if you just go through the Constituent Assembly debates, which are available, which are available from 1948, December 23rd onwards. In volume 7 and page number 23, there is a statement which is being made by Dr. Ambedkar. Dr. Ambedkar simply says, come what may, we will not thrust and force the uniform civil code on the minorities. This is what he said, because what was the reason for this? But before giving the reason of that, what exactly was the comments of the Constituent Assembly members? Now, I just intend to speak about 3 or 4 members only. They are the ones who are vociferous and strongly argued for the Uniform Civil Code. Now, we start with the K.M. Munshi. K.M. Munshi, when he spoke about the Uniform Civil Code, if the minority communities, general, no reference to anybody, if they say that religion is part of law, then it is just not possible to have a uniform civil code. Always, when we have a uniform civil code, remember, we have to think of other factors as well. And you have to prime consideration for national interest. Then what did Ambedkar point out? Ambedkar is the man who, when there was argument from both sides when it was going on, he just pointed out uniform civil code is just possible. Why it is not possible in this country? Although he gave an assurance that it will not be thrust on them. He was just concentrating on the criminal administration of justice. Now, when we speak about the criminal administration of justice, he was speaking about the Indian Penal Code. He was speaking about the Criminal Procedure Code. He was speaking about the Civil Procedure Code. The entire Criminal Procedure Code is made applicable to all the citizens of this country. There is no difference between caste, creed, and minority or majority. Everyone has to accept this. Then you think of the law of contract. The law of contract is being applied to everyone. Whether you are a Shia or a Sunni or a Brahmin or anybody. When you go to the court of law, it has to be applied. And there is no distinction as far as this law is concerned. And then he went to the extent of pointing out a few other laws as well. And I speak about the few other laws. These are instances which he gave in the Constituent Assembly. The first instance happened to be the instance of the state of Kerala. In the state of Kerala, in the Malabar region, in the North Malabar region, when we speak about the feminist law, you have Marumakkatayam cult. So it is called as Aliya Santana in Kannada. If you go to the Kasaragod region, they speak about Aliya Santana. So the Aliya Santana law, Marumakkatayam cult, is applicable, was made applicable both to Hindus as well as Muslims. And it was done without any trouble, without any problem, and it was observed, adhered, respected by peacefully by all the communities with it. Although it was meant only for a segment of the people, it was applied even to Muslims. Then he was giving the illustration of the law that was prevalent in the northwestern frontier. In the northwestern frontier, remember, there was no Sharia until 1937. Sharia was implemented, and it was implemented only after 1935. It was implemented after 1935 because until that date, all the Muslims were following, as in regard to succession, the Hindu law. So the Hindu law of succession prevailed in the northwestern frontier. The northwestern frontier at that time, remember, it goes to beyond the present Afghanistan, if at all. It was part of the state of India. Think of it. Now then, he gave the illustration of the Bombay province. In the Bombay province as well, that is the Maharashtra province, up to 1937, there was no implementation of the Sharia for Muslims. Only Hindu law was applied. Now, in addition to this, even in the central provinces as well, up to 1937, the Hindu law actually prevailed, and there was no what we call as Mohammedan law or the Sharia, which was made applicable to the Muslims. So when that was done, when that was actually peacefully applied and peacefully received, and cases are being resolved, what is the hitch and hiccup? This is the fundamental question which everyone should ask. Now, if these are the things which he said, I just told you about Ambedkar. Then what did Alladi Krishnaswamy Iyer point out? Alladi Krishnaswamy Iyer simply said, now you have laws which are enacted by the British government. And these laws which are enacted by the British government are actually influenced by the Anglo-Indian jurisprudence. And this law which is being enacted by the government of India through the British were influenced by the Anglo-Indian jurisprudence. Naturally, it was made applicable to Mohammedans. Then he was just saying, if you take into consideration the application of contract law, prior to 1948, 1950, remember, it was applied between Muslims and Hindus and Muslims. I am quoting the statement of the great Alladi Krishnaswamy Iyer. Oh, when it was applied like that, where is the hiccup? And this should not be allowed to done. K.M. Munshi always wanted to say, if religious considerations are taken into consideration, I don't think we will have a uniform civil code in India. And it is just not possible. Now, having said this much, I just intend to speak to you a few of the cases which were decided by the courts. And what exactly the issues that are involved, and what was the law, and how the judgments were delivered. Now, one such case happened to be, which most of you know, Shahbanu's case. It was 1985. In 1985, the famous Shahbanu case came up. And Shahbanu happened to be a woman who was 62. And at the age of 62, she was divorced by pronouncing talaq. And remember, she was ousted from the house. And the lady goes to the court of law and asks for maintenance. When she was asking for maintenance, the court granted alimony and maintenance, whatever it is, under section 125 of the CRPC. Now, when this was done, remember, the Muslim communities just did not like this. And when they did not like this, the maintenance for a divorced woman under Islamic law can be given only for 100 days. That is to the period of iddat. When once the period of iddat gets over, she is not entitled to any kind of compensation, whatever, from any source. Now, Muslims said, why the courts are interfering in the administration of justice? Now, this is Islamic law. And this is fundamental to us. And the administrators, the ruling people, wanted to influence the voters and to get their support. And then came a law that was passed by the then government. And they said, Muslim women's protection in the event of divorce. And the law simply stated, under 3.1, she is entitled to claim compensation only during the period of iddat. At a later stage, this was challenged in 2 cases. I don't wish to make a mention of those cases. And in those 2 cases, when it was challenged, the court pointed out that any law which is being enacted by the parliament, if it contravenes section 125, it is unconstitutional. Very simple. So, with the result, the law which was enacted, remember, for providing iddat only for 100 days was considered unconstitutional, and there was a deep burial. See, this is the first day wherein in 1985 the issue started surfacing. And many of the judges, sir will be knowing, sir, if I have any mistake, please correct me, sir. Now, there are instances wherein they went to the extent of pointing out what we call as uniform civil code is very much essential. And that will solve the problems. And in order to solve the problems, it has to be done, come what may. And when this was done, there were cases, a beautiful case came up, Sarala Mudugal versus Union of India. And in Sarala Mudugal versus Union of India, the question is very simple. Now, what has happened is, Here is a person, Mr. X, he gets married to a lady under Hindu law. The marriage has taken place under the provisions of the Hindu Marriage Act, 1955. And thereafterwards, remember, he intends to take another wife after converting himself to the Islamic faith. His marriage has taken place under Hindu Marriage Act, and he converts himself to Islam. Then he takes the second wife. Now, when it was challenged before the court of law by an NGO known as Kalyani, which was led by Sarla Mudugal, the first issue is does this relate to bigamy? Section 493 of the Indian Penal Code. It hits the Indian Penal Code or not was the question that came in. See, during the substance of the first marriage, when the first marriage itself is in force, a Hindu who has married and taken a wife in accordance with the Hindu law, how can he take the second wife? And if he takes the second wife, remember, the law of bigamy will come into and it will hit and the marriage is void. So it is at this juncture, during the course of judgment, they said, now what we call as uniform civil code is very much essential. Now this is only to unite and to keep the integrity of the nation. And naturally, to keep the integrity of the nation, a uniform one law for one nation is a must. This was another. There was another case which came before the court of law. And in this case, that happened to be the third case, remember, a Muslim woman wanted to adopt a child. And in the Islamic law, it was not allowed. Because in the event of adoption, she is not equally treated. But then there was a legislation which was passed by the Indian government, and which is popularly known as the Juvenile Justice Act. Under the Juvenile Justice Act of 2000, a woman is entitled to adopt a child. A Muslim woman is entitled to adopt a child. And she adopts a child. And when the matter goes to the court of law, the court pointed out, no, there is nothing wrong in it. And naturally, everyone should come to the mainstream. The law should be uniform. And it should be made applicable throughout the territory of India. Now, these are a few cases that came for purpose of discussion. Now the other part of the story is, 2-3 issues came up. One is whether the rituals or whether the practices and the precepts of a particular religion come in the way of the adoption of the Uniform Civil Code. Your practices and beliefs and the precepts, you are entitled to firm up. Nobody will interfere. Nobody will interfere with that. Only thing is, everyone has to be treated equally. In Sarla Mudugal case, and subsequent to that, there was another case which came up, wherein the judges of the Supreme Court, especially Kuldeep Singh and another, they harped upon in saying, all laws, whether it is based on religion or whether it is based on morality, must undergo the test of human rights. And if they are against basic human rights, remember, it will lead to discontentment and torture. We don't want such things to happen. Now, when I speak of this, you might be knowing, India became independent, and after becoming independent, we had ratified several international conventions on this. When I speak of this, we became a party to the Charter of United Nations. Now, under Article 1, Paragraph 3 of the Charter of United Nations, distinction based on race, sex, religion, and sectoral group is absolutely prohibited. No person is allowed to show any kind of discrimination between male and female and race. Apartheid cannot be practiced. That is how, remember, the independence movement of almost 60 countries have taken place. Now, non-discrimination. self-determination. All of them became part of the law of United Nations. A great writer who is the head of the Princeton Law School, Richard Fack, he was saying, in support of this human rights, there are certain resolutions which are binding, which gets the characteristics of customary rule of international law. They get the characteristics of customary rule of international law for the simple reason, before the resolution is moved, the permission how the House is taken. When the permission of the House is taken and after its permission, if the resolution is passed unanimously without dissent, it is an instant customary international law. Now take the instance of self-determination. And self-determination is each country is sovereign to have a government of its choice. And colonialism had to come to an end. Then thereafterwards we have resolutions on what we call as sovereignty over natural resources. Each country is competent to determine and explore and exploit the resources by itself. Now there are many others, because this is not the forum to speak on that. Now when it is accepted and practiced unanimously with voice vote, it becomes instant rules of customary international law. This is what this person has said. And there was another Harvard scholar who equally supported him. Now point is, the Charter in 1 paragraph 3 just indicated discrimination based on race, sex, religion and place of birth is absolutely prohibited. Thereafter we have Article 55 of the Charter of United Nations. And it speaks exclusively about human rights and its protection throughout the world. And then Article 56, I just tell you the relevant portion. States are supposed to take joint and separate action for the enforcement of these rights which are mentioned in Article 55. So what do you mean by joint and separate action? You have ratified the treaty. United Nations has come into force in your country. And as per the law of the United Nations, you have accepted to accept it in the territory. But whether it is in conformity with the Charter of United Nations, this is one question. Now the second thing is, the other developments that has led is, after 1945, the Universal Declaration came into force. When the Universal Declaration came into force in 1948 on December 10th, remember, again with voice vote it was adopted. There were 30 articles, 21 of which speak about civil and political rights. And the remaining 7 articles speak about economic, social and cultural rights. Now at that time, Lord Denning once gave a judgment in a court of law in England, how it impacted for the adoption of International Covenant on Civil and Political Rights. Lord Denning, in one of the judgments in England, he just pointed out, the Universal Declaration has no binding force. In the Universal Declaration, there are no litigants. Under the Universal Declaration, you cannot book a case. It is, to a certain extent, is a useless document. The United Nations realized the pulse of the problem and the gravity of the situation, and then immediately called the Human Rights Commission to have a convention on human rights. And immediately, remember, by 1950-51, the United Nations Convention on Civil and Political Rights came in. But then, there were differences of opinion. States were not prepared to ratify. See, from 1951 to 1967, they dragged, and in 1967, it was adopted. Both the economic, social, cultural rights, and civil and political rights. And they came in 1976. When once it was adopted, minimum ratification, 35 members had to ratify this, otherwise it would not come into force. And it took another 10 years, 1976, and it came into force. And India is a party to it. All rights, basic rights, which are sacrosanct to women, are being enshrined in the civil and political rights, in the economic, social and cultural rights. How long we can bluff the people of the world without implementing it? These are a few of the things which I just wanted to bring in. Many things can be spoken, but I just want to read a statement which was stated by the Honorable Justice Gajendra Gadkar. Honorable Gajendra Gadkar, in one of the writings, which was published in Bhavan's Journal, it was in 1971, as early as 1971. He indicated the non-implementation of the provisions contained in Article 44 amounts to a grave failure of Indian democracy. Amounts to a grave failure of Indian democracy. He said whether or not polygamy should be allowed, what should be the line of succession, what should be the share of different heirs, what should be allowed, what should be the law of divorce, are matters which should be determined not by scriptural injunctions. It is by rational considerations. This is what he has said. So first is rationality should prevail. Rational consideration should be there. And principle of tolerance, which even Willurant, in his book, the last 11th volume, Lessons of History, points out. It is because of the tolerant civilizations have survived. If intolerance continue and continues to flourish, all of us will perish. Once again, thank you, with best wishes.
Thank you, sir. So we'll open out the session for a few question and answers before we have the closing remarks by the chairman. So any questions people can. So I see a few raised hands, so I will start. Next.
Thank you, Professor. Absolutely insightful, absolutely hit the ball outside the park. As an observer, and I'm not a student of law, I just have a short question for you. I think you summed up on possibly a very high note. Civilization and tolerance. Is it a subtext of law, or does it overarch law in general? Thank you.
Arnold J. Toynbee, who is the historian at the University of Cambridge, wrote 24 volumes in his study of history. Arnold J. Toynbee, the British historian, who wrote the study of history in 24 volumes, examines and analyzes the civilizations of the world. When he examines civilizations of the world, he gives reasons for his peril, climax and peril. So this is a word that is being used. In every civilization there will be climax and there will be peril as well. Now the climax, it goes because of the contribution that is being done. And the peril because the people did not like the administration for the things which they have done to them. So in such a situation, remember, both of them go hand in hand. For example, you take the instance of the Roman Empire itself. A few of you will have seen a few movies, Ben-Hur, Solomon and Sheba, and the other one, about 15 years ago, there is another movie which came in, wherein how these slaves were treated. Very badly they treated. And today's Romans boast of their civilization throughout the world. And during their administration, they went on boasting. But although they went on boasting, it was just like a black spot on the sun. And today, all the states, the developing countries, the least developed countries, just say, what Roman Empire? All law is made for their benefit, not for the benefit of what we call as the poorest of the poor. In this way, it has to be analyzed. Yes, any other?
Yeah, incidentally, Arnold Toynbee you quoted, and he visited this institute and also delivered a lecture, and Justice was here. He keeps recalling about Toynbee's lecture here. So
Yeah.
thank you, sir.
Yeah.
Yeah, thank you for a very enlightening lecture, sir. Actually, I just had one doubt. If I understood your speech correctly, you had indicated that Dr. Ambedkar had left it to the directive principles, which means the states would have to probably intervene in enacting a UCC. Is that what you meant, sir?
No. Sorry. It was not like that. What Ambedkar was saying was, without any hiccup, it will come. And it can be enforced. And it can be a law as well. So, codes, Uniform Civil Code will come in. That is why he was giving the instance of the Criminal Administration of Justice and the laws, Indian Penal Code, then the Civil Law, Civil Procedure Code, Criminal Procedure Code, then Law of Contracts, all of them. And there are in every spheres, remember, even in Muslim law, I was reading a book in the morning, even in Muslim law there are certain provisions that are influenced by the Anglo-Indian jurisprudence, which is part of the Islamic law. That is why it is possible. Only thing is, one of the Poker Sahib, he was one of the members, I didn't make a reference to them, I have all of them, what they have said. Poker Sahib is the man who went to the extent of pointing out, then Naziruddin Ahmad, these are the two. Naziruddin Ahmad and Poker Sahib are the one who said time is not ripe. And it requires persuasion. And only through persuasion this can be possible. And it will take time.
Sir,
They were members of the Constituent Assembly. That is the reason I invoked.
Sir, regarding the human rights violation, I mean, every time, the subject of UCC comes, they bring in human right violation with respect to their respective religious practices. And how do we look at it and overcome this?
Yeah.
Thank you.
Now, for you, I will just quote a sentence from Honorable Justice Sahai. That will give a very good reply. See, what he has said, Honorable Justice Sahai, ours is a secular democratic republic. There is no disagreement on that. Freedom of religion is the core of our culture. Be he is a Hindu or a Muslim or a Christian or a Parsi. There are 12 religions in the world. All the subjects in India, remember, there are nationals belong to all the 12 religions. We have people here. People belonging to all 12 religions are found here. You just see, the Nani Palkiwala has written a book, that is The Nation, wherein you can get this information so beautifully summarized, and wherein he was telling there are certain things which are disappearing very fast, and it should not have happened, and for which we the elders should be in a position to see that it is continued. One of the things is obedience to the unenforceable. When I speak about obedience to the unenforceable, naturally when we see our parents, we prostrate before them. Knowledgeable persons, when we meet them, we prostrate with them before them. On important ceremonies, we take the blessings of everyone, and slowly and steadily it is sidelined. That is part of Indian culture. You may be knowing King Yasha, when he was going before the meeting of the Council of Ministers, he used to prostrate before them. the Buddhist monks. Just prostrate before them. There is Ashoka. King Ashoka, when he was going for the cabinet meeting, before the meeting he would prostrate before the Buddhist monks. His minister, Yasha, puts a question. What is this you are doing? Prostrating before Buddhist monks? Then he tells him, it is because of their wisdom we run the administration. And we have to respect them. And respect can come only through the head of the state, because he should first prostrate before them. That is disappearing in this country. Now, ours is a secular democratic republic. Freedom of religion is the core of our culture. Even the slightest of deviation shakes the social fabric. Even the slightest of deviation shakes the social fabric. But religious practice, violative of human rights and dignity and sacerdotal, suffocation of essentially civil and material freedoms are not autonomy, but it is oppression. This is what he said. It is not autonomy, it is oppression. Yeah, anything?
ಹಲೋ ಸರ್, ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬೋದಾ?
ಕೇಳಿ.
ಸರ್, ಈಗ ಕಳೆದ ಶತಮಾನದಲ್ಲಿ ಮತ್ತು ದಶಕದಲ್ಲಿ ಹಲವಾರು ಕಾನೂನುಗಳು ಬದಲಾವಣೆ ತಂದು ನಮಗೆಲ್ಲ ಒಳ್ಳೆಯದಾಗಿದೆ. ಉದಾಹರಣೆಗೆ ಬಾಲ್ಯವಿವಾಹ ರದ್ದತಿ, ಸತಿಸಹಗಮನ, ವಿಧವಾ ವಿವಾಹ, ವಿವಾಹ ವಿಚ್ಛೇದನ, ಸೋಡಾ ಚೀಟಿ ಅಂತ ಕೊಡ್ತಿದ್ರು. ಈ ಉತ್ತರ ಕರ್ನಾಟಕದಲ್ಲಿ ಸೋಡಾ ಚೀಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಡೈವರ್ಸ್ ಅಂತ ಆಗ್ತಿತ್ತು. ಅದು 70-80ನೇ ಇಸ್ವಿವರೆಗೂ ಚಾಲ್ತಿಯಲ್ಲಿತ್ತು. ಆಮೇಲಿಂದ ಕಾನೂನಾತ್ಮಕ ಅದನ್ನು ರದ್ದು ಮಾಡಿದ ಮೇಲೆ ಜನಗಳು ಭಾಳ ಸಂತೋಷವಾಗಿದ್ದಾರೆ. ಹಾಗೆ ಪಾಲಿಗಾಮಿ, ಅಟ್ರಾಸಿಟಿ ಅಗೇನ್ಸ್ಟ್ SC/ST, ಈಕ್ವಲ್ ಶೇರ್ ಟು ವುಮನ್, ಎಡೆ ಸ್ನಾನ, ಮಡೆ ಸ್ನಾನ ಅವೆಲ್ಲ ತಂದಾಗ ಜನಗಳೆಲ್ಲ ವಿರೋಧ ಮಾಡ್ತಿದ್ರು. ನಾವು ಮಡೆ ಸ್ನಾನ ಮಾಡ್ತೀವಿ, ನಾವು ತಲಾಂತರಗಳಿಂದ ಮಾಡ್ತಾಯಿದ್ದೀವಿ, ಈಗಲೂ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೀವಿ, ನಮ್ಮ ಅಡ್ಡಿ ಬರಬೇಡಿ ಅಂತ. ಆದರೆ ಅದನ್ನು ಕಾನೂನು ತಂದು ಅದನ್ನು ನಿವಾರಣೆ ಮಾಡಿದ ಮೇಲೆ ಜನಗಳು ಸಂತೋಷವಾಗಿದ್ದಾರೆ. ತೀರಾ ಇತ್ತೀಚೆಗೆ ಅಂದರೆ ಆರ್ಟಿಕಲ್ 370 ರದ್ದು ಮಾಡಿದರು. ಈ ರದ್ದು ಮಾಡಿದ ಮೇಲೆ ನಿಜವಾಗ್ಲೂ ಕಾಶ್ಮೀರದಲ್ಲಿ ಜನ ಸಂತೋಷವಾಗಿದ್ದಾರೋ ದುಃಖದಲ್ಲಿದ್ದಾರೋ, ನಮ್ಮ ಇದನ್ನು ವಿರೋಧ ಮಾಡೋರು ಯೋಚನೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತೀನಿ. ಇವತ್ತು ನಮ್ಮ 370 ರದ್ದಾದ ಮೇಲೆ ನಿಜವಾದ ಅಖಂಡ ಭಾರತ ಇಲ್ಲ. ಹೇಳ್ತೀನಿ ನಾನು.
There is no question, it is a statement.
It is not a question. I told you in advance.
I understood. Yeah.
I am not putting. I am complimentary to what Subrahmanya told.
Yeah, I understand.
Article 3.
Even I wanted to tell this. For example, reforms have come in our law. And if reforms have come in our law, why not in others?
Yeah, definitely.
That is what he is telling.
ಆರ್ಟಿಕಲ್ 370 ರದ್ದಾದ ಮೇಲೆ ನಿಜವಾದ ಅಖಂಡ ಭಾರತ ಸೃಷ್ಟಿ ಆಯಿತು 76 ವರ್ಷಗಳ ನಂತರ. ಈಗ ಈ UCC ಅಪೋಸ್ ಮಾಡೋ ನಮ್ಮ ಸ್ನೇಹಿತರಿಗೆ ನಾನು ಕೇಳೋದು,
respect the speaker and state a question, and if people are able to make a good lecture, we will hold one, and we also have a podcast here, so we will organize that. So thank you, sir, no disrespect. So we'll keep it like, we'll pose the questions and we'll take benefit of Justice M.N. Vin's presence here and Professor T.R. Subrahmanyam. Thank you once again. Pose your question, keep it simple.
Is enforcing the law is better or implementing the law is better in view of the religious prohibitions? Is enforcing the law is better or implementing the law is better considering the religious aspects of our country?
If you say the choice is between a forcible enforcement of a legal provision or persuading people voluntarily to obey the law, the choice is obvious. Nobody need answer that question, that a peaceful implementation of the law is preferable to forcible execution of the law. This is I think that question may perhaps not be totally relevant to the topic of discussion today. We have just heard a spellbinding address by a learned professor without a scrap of paper in his hands. He took us into a journey across the frontiers of the subject, the source of the power of the state to make a law, the limitations of the powers of the state to make the limitation of the extent to which the law could go. These are all civilizational issues today. And the eminent professor took us into a journey across the history of this subject from the beginning and explained to us how personal laws are also amenable to regulation in the larger interests of society. Ladies and gentlemen, this is a real tribute to the memory of the great professor, Professor N.A. Nikam, who was a very, very eminent professor of philosophy. And if I may say so, Hindu law became codified in the year 1955. Even in the Hindu law of succession and inheritance, in partition, there were several conflicts amongst the many schools. There was the Mithila school, the Banaras school, the Ratnagiri school, the Mysore school, the Madras school. Each one of them had their own emphasis, and the persons were entitled to a share at a partition. For example, if the father and the sons effected a partition of joint family property, whether the mother had a share at all or not. The Madras school said no. The Mysore school said no. The Ratnagiri school said yes. The Banaras and the Mithila schools had their own views. The Daibhaga system of Bengal had a totally different take on the matter. It took almost 70 years to codify the Hindu law of succession, Hindu law of marriage, Hindu law of adoption and maintenance, and 4 legislations of 1955 had a 70 years history. There was Sir Benegal Narsingh Rao's committee to bring about reforms in Hindu law earlier. In 1944, Dr. Ambedkar became chairman of the committee to reform Hindu law. There was the proposal to have a Hindu code had immense opposition from the Shastric scholars of the country. Even the President Rajendra Prasad had expressed his own reservations about interference of the state in the personal laws of the Hindus. And the 1955 culmination of the reform, Hindu law reforms, culminating in the 4 statutes that came about in 1955 is itself a historic event. In a non-trivial sense, that gave us an indication of the nature of the subject we are dealing with, the power of the state. These are all issues that are intertwined. It is not merely reforming Hindu law of succession, but essentially a welfare state, what is the extent of the power of the welfare state to interfere with the personal affairs of the Hindus or the Muslims or the Parsis. In fact, the professor's talk today laid the foundation for clarity of the nature of the power. For example, the Code of Justinian, Napoleonic Code. The Romans ruled Britain for 300 years. And the Romans were known for their great edifices, buildings, grandeur. The Greeks were known for their philosophy. The professor took us into an exciting journey into the affairs of the Roman Empire and the Justinian, Code of Justinian. The scholars, in fact, it's a fascinating subject for law students to know how the Code of Justinian and the European civil law system, the concept of precedent in law. It's a fascinating subject for law students, and it's only masters like the speaker today that can convey these things in such such erudite and intelligible manner in which all of us, even laymen, can understand the intricacies and beauty of this kind of evolution of the principles of civilization. Somebody mentioned about Toynbee. Toynbee's take on, he spoke of the biological evolution, ascent and descent of collapse of civilizations. He spoke of a principle called Volkerwanderung, biological interpretation of civilizations. A society which becomes weak by a repeated indulgence in the pleasures of life becomes so effeminate and weak and loses its martial spirit that the tribal surrounding tribal population will invade them. And there's an intermixture of the blood, and a new civilization springs out from that kind of conjugation. That's the kind of theory that one of the theories of Arnold Toynbee in the study of history. These disciplines are interwoven, and sociology, that's why a great legal luminary said, a lawyer who doesn't know sociology and economics is apt to be a public enemy. And this is the kind of, the law is a confluence of philosophy, psychology, sociology, economics, and every field of human endeavor. And this is where professors of the type we have had the pleasure to listen to today contribute to what is civilizational virtually. In fact, when Ambedkar accepted to be chairman of the committee to bring about the reforms in 1944, there was a tremendous opposition to even the President Rajendra Prasad that raised his eyebrows on the effort, and see and how many things that basically there are certain fundamental concepts. What is the limit of the state to interfere with the affairs of an individual? Supposing I want to bequeath my estate to a friend and deny my dependents, my heirs and dependents of my property, my self-acquired property, what is the business of the state to interfere and say you can't do that? And very interesting examples are available. In 1938, England passed a statute, a law, Inheritance Family Provision Act of 1938. They said that you by will, a person cannot by will give away more than 1/3 of his share to an outsider. That's an Islamic law principle. They borrowed that principle from Islamic law and made it a part of English law in 1938. In 1975, that law was amended, and they said inheritance provisions for provisions for heirs and dependents act. That was in 1975. That said, the court has the power to redistribute the property in spite of his will, in spite of his testamentary status. He can redistribute the property to dependents. For example, he had a child outside marriage, and he had a relationship with a lady outside marriage. How they should be accommodated, the court was given that discretion. The property of a deceased would be redistributed at the discretion of the judge. That's the kind of the invasion of the law of privacy in regard to disposal of estate that was contemplated in England. Societies are changing at a very fast pace. The forces of social change compel rethinking on vital issues. How can the state, supposing as it was done in England, the court has the power to redistribute the estate of a deceased person amongst people who are really stakeholders in that estate. And these are changes, they are far ahead of our contemplated legislations. And for example, in the draft, the Uniform Civil Code that we are contemplating, by the time it comes into fruition, so many social factors will influence and compel change. For example, I was asked to chair a committee to draft ethical guidelines on biogenetic research for medical scientists. I had a team of 40 very eminent scientists working in the team. And when the report was ready, when I sent it to government, I said in the forwarding letter, by the time I come to the end of this letter, this report may become obsolete on account of the intensity of the change that is going to happen in the scientific world. Today, you have scientists say that just a pick of the earwax, just a drop of a person's urine and a drop of blood can tell a person who all the diseases that he has today and what are the kind of diseases that he's going to get from time to time in the future. They predicted to a cinema personality that that lady may have breast cancer 8 years later. There's an 80% chance that great film personality had her breast removed immediately to avoid the future operation. This is the kind of change that they are going to witness in the world. Tremendous things are happening, and these are adjustments, social adjustments that will have to support that kind of society that will emerge in the near future. And the felicity with which the professor recalled the entire events, the virtually evolution of the civil law system of the European systems and the adversarial system of England. And for centuries, the English scholars admired the continental system across the British Channel, but they did not incorporate it. The adversarial system of European countries have their own extraordinary merit of a judge being not merely an umpire. In the Indian context and in the adversarial system, a judge is like a cricket umpire. You say, how is that? You say, out or not out. That is not the system in Europe. The judge participates, gets the dust of the ring, and participates in the debate. This legislation, which is going to come up for the Uniform Civil Code, some 15 years ago when I was asked to comment on it, I said, first make a statutory introduction into the law of succession of the Islamic system. First make a law. The traditional complaint of the religious minorities were that a Hindu majority parliament cannot legislate on a religious law of the Muslims. That could have been that should have been overcome by a legislation of the provisions of the law of succession and personal laws of the Muslims, drafted by the Muslims themselves. The Muslim community itself, their experts and their scholars should develop a statute, and that should be passed by the parliament. And when interpreting those provisions in the light of the emerging human rights values, both the statutes of Hindus and the Muslims would be interpreted in such a way that there's a coalescing point that will be inevitable when they discuss the rights of children, discuss the rights of women, discuss the rights of others. They should apply the same international standards of human rights, and they would arrive at the same conclusion, and that will be the point of fusion. And but time has come that we should have a uniform civil code. Whether it is necessary or not, it is necessary. Is it feasible or not? It is feasible. It is desirable or not? It is desirable. And how they work it out without too much of friction among the society is the genius of the politician. I hope very soon that day will come. Thank you very much.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕಳೆದ 75 ನಿಮಿಷಗಳ ಕಾಲ ಇಬ್ಬರು ರಾಷ್ಟ್ರದ ಲೀಗಲ್ ಲ್ಯೂಮಿನರೀಸ್ ಅಂತಲೇ ಹೇಳಬೇಕು. ಒಬ್ಬರ ಭಾಷಣ, ಇನ್ನೊಬ್ಬರ ಅದ್ರ ಬಗ್ಗೆ ಕಾಮೆಂಟ್ಸ್ ಕೇಳುವಂಥ ಸೌಭಾಗ್ಯ ನಮ್ಮದಾಗಿತ್ತು ಅಂತ ಹೇಳಿದರೆ ಅತಿಶಯೋಕ್ತಿ ಅಲ್ಲ. ಇಂಥ ಗಹನವಾದ ಮತ್ತು ಗಂಭೀರವಾದ ವಿಷಯ, ಇದ್ರ ಬಗ್ಗೆ ಯಾರನ್ನ ನಾವು ಮಾತಾಡಲಿಕ್ಕೆ ಕರಿಬೇಕು ಅಂತ ಯೋಚನೆ ಮಾಡಿದಾಗ ನಮಗೆ ಹೊಳೆದದ್ದು ಮೊದಲು ಡಾಕ್ಟರ್ ಟಿ ಆರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರ ಹೆಸರೇ. ಯಾಕೆಂದರೆ ಕರ್ನಾಟಕದ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕುಲಪತಿಗಳಾಗಿ ನಿವೃತ್ತರಾದರವರು. ಸುಮಾರು 40 ವರ್ಷಕ್ಕೂ ಹೆಚ್ಚು ಕಾಲ ಬೋಧನೆ ಮಾಡಿದಂಥ, ಇದೇ ವಿಷಯವನ್ನು ಬೋಧನೆ ಮಾಡಿದಂಥ ಒಂದು ಅವರ ಏನು ಅನುಭವ ಇದೆ ಅದನ್ನು ಉಪಯೋಗಿಸ್ಕೋಬೇಕು ಅಂಥೇಳಿ ಅವರನ್ನು ನಾವು ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ದೂರವಾಣಿ ಮೂಲಕ ಕರೆದಾಗ ಅತ್ಯಂತ ಸಂತೋಷದಿಂದ ಒಪ್ಕೊಂಡ್ರು. ಅವರು ಹೇಗೆ ಮಾತಾಡಿದ್ರು ಅನ್ನೋದನ್ನು ಜಸ್ಟಿಸ್ ಆಗಲೇ ಹೇಳಿಬಿಟ್ಟಾರೆ. ಹಾಗಾಗಿ ನನಗೆ ಆ ತೊಂದರೆ ಇಲ್ಲ. ಈ ರೀತಿ ಅವರು ರೋಮನ್ ಕಾನೂನುಗಳಿಂದ ಯಾವ ರೀತಿ ಕಾನೂನುಗಳು ಬರಲಿಕ್ಕೆ ಪ್ರಾರಂಭ ಆಯಿತು, ಅದಾದ ನಂತರ ಗ್ರೀಕ್ ಕಾನೂನುಗಳು ಬಂತು ನೆಪೋಲಿಯನ್ ಇಂದ, ಈ ರೀತಿ ಇಡೀ ಕಾನೂನಿನ ವರ್ಷದ ಕಾನೂನಿನ ಇತಿಹಾಸವನ್ನೇ ನಮ್ಮ ಮುಂದೆ ತೆಗೆದಿಟ್ಟಾರೆ. ಅದ್ರ ಜೊತೆಗೆ ಭಾರತವಿತ್ತು ಐಸೋಲೇಟೆಡ್ ಕಾನೂನು ಮಾಡಲಿಕ್ಕಾಗಲ್ಲ, ನಾವು ಯಾವುದೇ ಕಾನೂನು ಮಾಡಿದರೂ ಕೂಡ ಅಂತಾರಾಷ್ಟ್ರೀಯ ನಿಯಮಗಳನ್ನು ಮೀರಿ ಮಾಡಲಿಕ್ಕಾಗಲ್ಲ ಅನ್ನೋ ಸಂಗತಿಯನ್ನು ಕೂಡ ಅತ್ಯಂತ ಸ್ಪಷ್ಟವಾಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಅವರಿಗೆ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ದ ವರ್ಲ್ಡ್ ಕಲ್ಚರ್ ಪರವಾಗಿ, ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪರವಾಗಿ ಗೌರವವನ್ನು ಸಲ್ಲಿಸಬೇಕು ಅಂಥೇಳಿ ನಾನು ಕೇಳ್ಕೊತೀನಿ. ಸಂಸ್ಥೆಯ ಕಾರ್ಯದರ್ಶಿ ಶ್ರೀ ವೆಂಕಟೇಶ್ ಅವರು. ನಮ್ಮ ಸಂಸ್ಥೆಯ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದರು, ಈಗ ನಮ್ಮ ಮಾರ್ಗದರ್ಶಕರಾಗಿ, ನಮ್ಮ ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ನ ಅಧ್ಯಕ್ಷರಾಗಿ ನಿರಂತರವಾಗಿ ನಮಗೆ ಮಾರ್ಗದರ್ಶನ ಮಾಡ್ತಾ ಬಂದಿದ್ದಾರೆ. ಮತ್ತು ವಯಸ್ಸಲ್ಲಿ ಹಿರಿಯರಾದರೂ ಕೂಡ ಉತ್ಸಾಹದಲ್ಲಿ ನಮ್ಮನ್ನೆಲ್ಲನ್ನು ನಾಚಿಸುವಂಥ ಒಂದು ವ್ಯಕ್ತಿತ್ವ ಜಸ್ಟಿಸ್ ವೆಂಕಟಾಚಲಯ್ಯನವ್ರದ್ದು. ಪದ್ಮವಿಭೂಷಣ ಜಸ್ಟಿಸ್ ವೆಂಕಟಾಚಲಯ್ಯನವರು ಈ ವಯಸ್ಸಿನಲ್ಲೂ ಕೂಡ ನಾವು ಈ ರೀತಿ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಇದೆ, ತಾವು ಬರಬೇಕು ಅಂತ ಕೇಳಿಕೊಂಡಾಗ ಅತ್ಯಂತ ಸಹರ್ಷದಿಂದ ಬಂದರು. ಇದಕ್ಕೆ ಮುಂಚೆ ಒಂದು ನಮ್ಮದೇ ಆದಂಥ ಆರ್ಟ್ ಎಕ್ಸಿಬಿಷನ್ ಏನಿತ್ತು ಅದರ ಉದ್ಘಾಟನೆಯಲ್ಲೂ ಅವರು ಭಾಗವಹಿಸಿದರು. ಅದಾದ ನಂತರ ಇಲ್ಲೂ ಕೂಡ ಭಾಗವಹಿಸಿ ತಮ್ಮ ಸುಮಾರು 7 ದಶಕಗಳಿಗಿಂತಲೂ ಹೆಚ್ಚಿನಾದಂಥದ್ದು ಅವರ ಕಾನೂನು ಅನುಭವ, ಅದರ ಆಧಾರದ ಮೇಲೆ ಇವತ್ತಿನ ಉಪನ್ಯಾಸಕರೇನು ಮಾತಾಡಿದರು ಅದರ ಮೇಲೆ ತಮ್ಮ ಪ್ರತಿಕ್ರಿಯೆಯನ್ನು ನೀಡಿದ್ದಾರೆ. ಮತ್ತು ಈ ಕಾರ್ಯಕ್ರಮದ ಮಹತ್ವವನ್ನು ಅವರು ಹೆಚ್ಚಿದ್ದಾರೆ ಅನ್ನೋದರಲ್ಲಿ ಸಂದೇಹನೇ ಇಲ್ಲ. ಇವತ್ತು ನಮ್ಮ ಕರೆಗೆ ಹೋಗೊಟ್ಟು ಬಂದು ಕಾರ್ಯಕ್ರಮದ ಮಹತ್ವವನ್ನು ಹೆಚ್ಚಿಸಿದಂಥ ಜಸ್ಟಿಸ್ ಎನ್ ವೆಂಕಟಾಚಲಯ್ಯನವರಿಗೂ ಕೂಡ ಧನ್ಯವಾದಗಳನ್ನು ಸಮರ್ಪಿಸ್ತೇನೆ. ಇವತ್ತು ನಮ್ಮ ಸಂಸ್ಥೆಯ ಅಧ್ಯಕ್ಷರಾದಂಥ ಡಾಕ್ಟರ್ ಸತ್ಯವತಿಯವರು ಕೂಡ ವೇದಿಕೆ ಮೇಲೆ ಉಪಸ್ಥಿತಿದ್ದು ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಅವರಿಗೂ ಧನ್ಯವಾದಗಳು. ಇದೆಲ್ಲದಕ್ಕೂ ಕಾರಣ ಯಾರು ನಮ್ಮಲ್ಲಿ ದತ್ತಿ ಇಟ್ಟಿದ್ದಾರೆ ಆ ದತ್ತಿ ಅವರು ಅಂಥೇಳಿ ಹೇಳಬೇಕಾಗತ್ತೆ. ಇವತ್ತಿನ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಕಾರಣಕರ್ತರಾದಂಥ ಪ್ರೊಫೆಸರ್ ಎನ್ ಎ ನಿಕಮ್, ಶ್ರೀಮತಿ ರಾಜಲಕ್ಷ್ಮಿ ಆನಂದ್ ಮತ್ತು ಶ್ರೀ ಎಚ್ ಎನ್ ಆನಂದ್, ಶ್ರೀಮತಿ ಸ್ವಯಂಪ್ರಭಾ ಬಾಲರಾಜ್ ನೆನಪಿನ ಈ ಏನು 3 ದತ್ತಿಗಳಿದೆ ಅದರ ಕಾರ್ಯಕ್ರಮ ಇವತ್ತಾಯಿತು. ಆ ಎಲ್ಲ ದತ್ತಿಗಳು ಮನೆಯವರು ಕೂಡ ಇವತ್ತು ಇಲ್ಲಿ ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಅವ್ರಿಗೂ ಕೂಡ ಸಂಸ್ಥೆ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. ಇವತ್ತಿನ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬಂದು ನೇರ ಭಾಗವಹಿಸಿ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕೆಲವು ಪ್ರಶ್ನೆಗಳನ್ನು ಕೇಳೋ ಮೂಲಕ ಇನ್ನೂ ಹೆಚ್ಚು ಜನಗಳಿಗೆ ಈ ವಿಷಯದ ಬಗ್ಗೆ ತಿಳುವಳಿಕೆ ಬರುವಂಥ ಮಾಡಿದ್ದೀರಾ. ಹಾಗಾಗಿ ಬಂದಿರತಕ್ಕಂಥ ಎಲ್ಲ ಶ್ರೋತೃಗಳಿಗೂ, ಅದೇ ರೀತಿ ಇದನ್ನು ಯೂಟ್ಯೂಬ್ ಮತ್ತು ಫೇಸ್ಬುಕ್ನಲ್ಲಿ ನೋಡ್ತಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ಕೂಡ ಸಂಸ್ಥೆ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನು ಸಮರ್ಪಿಸ್ತೇನೆ. ಕಾರ್ಯಕ್ರಮ ಮುಕ್ತಾಯ ಆಗಿದೆ.